Hello, and welcome to Proposition 19 and your estate plan. My name is Nicole Warmerdam of the Law Office of Nicole Warmerdam. I am a certified specialist in trusts and estates, and I've been practicing in this field for about 15 years. I do have some slides for our presentation today, so I'm going to go ahead and share my screen, and let's get started. Okay, as I said, we're here today to talk about Proposition 19 and your estate plan. For those of you joining me on YouTube, today is December 5th, 2020, and this is a pre-recorded presentation. I do have a few minor bits of housekeeping before we get started. You should know that I'm here today to give you an informational presentation about Proposition 19. I am not here to give you legal advice, and so we aren't actually creating an attorney-client relationship today. In addition, you should be aware that I'm going to be talking about mostly California related law. In addition, as I mentioned, this is a pre-recorded presentation. So you should be aware that laws can differ jurisdiction to jurisdiction, laws can change over time, and you should definitely not act or decline to act based on anything that I am sharing with you today. So with that out of the way, let's go ahead and get started. So Proposition 19 is on its way to narrowly passing in California. We won't have the final confirmation of the vote until December 11th, but at this point it looks like it is due to narrowly pass. Now, we don't know a lot right now, and that is because with any kind of a proposition, what generally happens is the legislature is going to step in at a certain point, and they're going to start proposing legislation to flesh out the provisions. In addition, the State Board of Equalization is likewise going to promulgate regulations and guidance on how the law should be implemented. What you really need to know today is that Proposition 19 is going to be effective February 16th of 2021. So just a few short months from now. Because that is actually at or around a holiday, the date that I would like to have you in the back of your mind in terms of if you're thinking of taking any action is actually February 11th. So we're going to use February 11th for our purposes. So in addition to the date for Prop 19, what you really need to know is that Proposition 19 modifies the Property 13 property tax laws that we've largely taken for granted over the last several decades. Most of us may not know of the particulars of the rule, especially if you are a layperson and you don't practice in this field. But we generally know the effect of Proposition 13. And so today I'm going to be talking to you about how that is going to change. Some of the things to be aware of, rather than just kind of dwelling on the cons of Prop 19, is that Prop 19 is likely going to result in an increase of tax revenue. That revenue is going to be going back into our public schools and also into the creation of a fire response fund. And so that's where those tax dollars are going to be earmarked for. Now, kind of following along on that, Prop 19 actually does expand portions of Prop 90 and Prop 60 in some really great ways. If you're over 55, if you are disabled, or if you have lost your home in a natural disaster, then listen up because Proposition 19 does have some benefit for you. And this is because Prop 19 is going to allow you to take your low property tax basis with you to a new home up to 3 times in your life. So you can sell a home in which you were paying very low property taxes, go out and purchase a new home, and you can bring those taxes with you. You're not going to be paying the fair market value taxes on that new home. And of course, as I mentioned, you can do that up to 3 times. Now, we had a similar law on the books. There was a limit of 1 time. In addition, there was a limit of the value of the new home. The new home had to be worth less. As I will be showing you in this case, you can actually upsize and not just downsize and still get some benefit from Prop 19 and its provisions. In addition, the old law was really limited to a handful of counties. They had a reciprocal arrangement. If you moved from one to the other or within one of them, then you could take advantage of this. With Prop 19, this ability to carry your property tax basis with you actually applies to all counties within California. And so if somebody's looking to downsize, upsize, move around the state for various reasons, the benefits are not necessarily going to be lost. So let's actually talk about what this looks like in the real world. So let's say, we've got a couple and they are looking to downsize. They're looking to move into a smaller home. Right now, the home that they have is currently worth $1.1 million. The assessed value, however, is much lower. They purchased this house a while ago. It has an assessed value of $160,000. Now, as I said, they're downsizing a little bit, not too much. They're looking to buy a modest condo in a really nice area. They're looking to spend about $900,000. Now, currently, because their residence has such a low assessed value, they're paying very low property taxes. Using kind of an average rate for California, and again, I'm not looking at some of the add-ons that the cities and counties have for property taxes, they're probably paying about $1,700 a year in property taxes. That's at an average 1.1% rate. So very low property taxes for a home of that size. Now, what's great is because they are, downsizing, they're over 55, they've, picked the new home, it's $900,000. They're not going to be paying property taxes based on the new $900,000 condo. They're going to get to take their property taxes, their $1,700 in property taxes with them, and they're going to continue to pay that low property tax rate, even once they've made themselves at home in the new condo. Now, that rule, like I said, was a rule that we kind of had with us all along, but let's look what happens when somebody decides they want to upsize. So, they've got that same residence, that lovely little home, $1.1 million in this area, with the assessed value of $160,000. And, maybe because of, the circumstances and what's going on right now, they're not empty nesters anymore, or, their children have moved back into the home, or they want to have space for family to visit when, all of this madness of 2020 is over. And so they're looking to upsize. They have found a really nice house for $1.5 million. And again, they're currently paying very low property taxes, roughly $1,700 a year. Now, under the previous law, they would have been out of luck. If they would have bought this new upsized residence, they would be paying property taxes based on the purchase price, $1.5 million, which is considerably higher. However, now, under Prop 19, they are able to actually take their property taxes with them with a little bit of an adjustment. And so essentially how this works is you get to take your property taxes with you up to the value of your current residence, and then they just add on the difference between the value of your current residence and the value of the new residence. And so essentially what happens in calculating their new taxes is they have their assessed value of $160,000. And they're going to add to that the $400,000 difference between old home and new home. And so their new base year value is going to be $560,000. And again, using that average rate of tax of about 1.1%, their taxes are going to be roughly $6,000 a year. Now, I know that does sound considerably higher, but keep in mind, they're still only paying property taxes based on a base year value of $560,000, not $1.5 million. And so there is a very large savings at play here, even if they're looking to upsize their house. So those were some of the pros of Prop 19, which I do think are deserving of some mention. However, this presentation is really about Prop 19 and your estate plan. And so unfortunately, I'm here to talk to you today a little bit about what some of the cons of Prop 19 are. Before I dive into that, I think it is a good idea to refresh your recollection, if you will, about what some of the current property tax exclusions are. These are the exclusions that are going to be changing under Prop 19. So when I'm talking about property tax exclusions, what I'm talking about is if there's a transfer of real property, generally speaking, that transfer is treated as an event, and then the assessor's office is able to reassess the value of the property that's being transferred to fair market value, and they're able to adjust the property taxes accordingly. And so when you think of transfer, or when you hear me talking about transfer, what you should be keeping in mind is this is any transfer of property by gift, by sale, and yes, when somebody passes away, they do consider death to be a transfer event. And so keep in mind those three things when I'm talking about transfers, because the exclusions that we're going to be talking about are types of transfers that don't result in a reassessment. And again, these are property tax exclusions that we have largely taken for granted for the past several decades. The first exclusion that you all are probably aware of are transfers between spouses or transfers between domestic partners. Really, the gift, sale, or inheritance of any real property between spouses or domestic partners is completely excluded from reassessment. You get to transfer your current property taxes to that spouse or that domestic partner. For transfers between parents and children, there are a couple different kinds of exclusions. It's not quite the same as the blanket exclusion with spouses and domestic partners. The first is the gift, sale, or inheritance of any primary residence. So that is the residence that you live in, the residence that you have actually taken the homestead exemption for through the assessor's office. You check the box and you take the homestead exemption. That is your primary residence. And so the gift, sale, or inheritance of that by your children is completely excluded from property tax reassessment under current rules. In addition, you can actually transfer other real property. So that is, other homes, commercial properties, you name it, really anything other than that primary residence. There's a little bit of a limit here, and the limit is you can cumulatively transfer up to $1 million of that other real property. And what's good to know here is the $1 million, that number that you're aiming for, is not a fair market value number. It is a base year value number. And so you're able to actually go back and look at the low property tax base of properties in your portfolio. And those are the numbers that you use to calculate the $1 million. So as you might imagine, if you've been holding a portfolio of property for a while, it's very likely it's got very low property tax base values. And so because of that, you're often able to transfer, more than one piece of real property under this other real property exclusion. And then finally, very similar to the parent-child, there is the grandparent-grandchild exclusion. Again, there is a primary residence exclusion and $1 million of other real property. We don't talk about this one too much, and that's because there are several limitations with the grandparent-grandchild exclusion. The one that's usually the most difficult to get around is that the intervening child or children must have passed away. And so I'm going to really focus today on talking about parent and child, but grandparent and grandchild will be applicable as well. And so as you can see, I have put a star next to the parent-child and the grandparent-grandchild exclusion. I'm going to be focusing a lot on those today because those seem to be the exclusions that are largely affected by Proposition 19. The spousal exclusion for most practitioners seems safe. And that's because Proposition 19 is amending a certain section of the California Constitution, Section 2H, for any of you code heads that want to go out and check that out. Not only does it not mention any type of spouse or domestic partner transfer in its language, these particular types of transfers are actually excluded under Section 2G of the California Constitution, which is a completely different section. And so it really does appear that transfers between spouses or domestic partners are going to be sheltered. And so what's really at play when I'm talking to you about the cons of Proposition 19 and its limits on Proposition 58 and 193, we're talking about the parent-child exclusion and the grandparent-grandchild exclusion. So the bad news is that Proposition 19 abolishes the parent-child and the grandparent-grandchild exclusions for any property not being used as a primary residence or a farm. And so when I was talking before about exclusions for other real property, that's gone. There is an exclusion for your primary residence, that is the residence that you have specifically checked the box on the document with the assessor's office for the homestead exclusion, or a farm. Now, as if that wasn't bad enough, there are further limitations. So if you qualify for the parent-child or the grandparent-grandchild, potentially because you are transferring a primary residence or a farm, there are further limits on the amount of the exclusion. And so the limit on the amount of the exclusion is that low base year value for your residence or farm, plus $1 million of appreciation, and that's going to be indexed for inflation over time. And so if you have a primary residence or a farm that exceeds $1 million, it is going to be partially reassessed. We don't have all of the details. It looks like there's going to be a little bit of a complex calculation at play, and that it is not necessarily going to be a reassessment to fair market value on that portion of the property that exceeds base year value plus $1 million. So let's take a look at this. Let's look at some examples of the current structure versus the new tax structure. Again, we've got that same lovely little home for $1.1 million with the assessed value of $160,000. Again, I know this number kills me. The property taxes that our couple is currently paying are about $1,700 a year. So, under Prop 19, we look at the base year value, which is $160,000. We're able to add $1 million for appreciation, and that is $1,160,000. And so because of that, the property taxes for anyone who receives this home as a gift or as an inheritance is going to continue to have the low property taxes of $1,760 a year. And that's because $1.1 million, the fair market value, is less than the assessed value plus $1 million of appreciation. So if you are a child, again, receiving this by a gift or inheriting this from your family, you're going to keep their low property taxes. But let's change the facts a little bit. Let's say, particularly in the Bay Area, that this lovely little home is actually 2,600,000. That is a recent appraisal. So that is the fair market, the going rate of this home in the area. We have the same assessed value, which is $160,000. And again, mom and dad paying $1,700 in property taxes. So let's say mom and dad transfer this to child, or, unfortunately, mom and dad pass away and child inherits this property. What's going to happen with the property taxes? Well, you can probably hazard a guess, because $2.6 million is a lot more than $1,160,000. Again, it's that $160,000 in assessed value plus $1 million in appreciation. And so we don't know all of the facts, but what we do know is that the child that inherits this or is gifted this is going to be paying $1,760 in property taxes plus some amount of additional taxes on about $1,400,000 in appreciation. And for those of you who have the misfortune of maybe paying close to fair market value property tax on your residences, you know that $1,400,000 is nothing to sneeze at. And so it's very likely that this property is going to be inherited or received by child with a very hefty increase in property taxes. So we've talked a lot about the primary residence, and we know that there is an exclusion, and it may not necessarily cover everything, but there is an exclusion. Let's take a look at the stark new reality for other types of real property. I'm going to use an example here of a family that not only has a primary residence, but has a couple of pieces of investment property. They have a nice small portfolio of Bay Area real estate. So they've got a vacation home with an assessed value of $450,000 and a fair market value of $750,000. They've got a rental home with an assessed value of $160,000 and a fair market value of $2 million. So they've been hanging on to that one for a while. Similarly, they have a second rental with an assessed value of $130,000, and again, a pretty high fair market value of $950,000. But these are pretty common valuations in the Bay Area. Now, I have a little note here because I do think it's important to share this with you. The assessed values of these three pieces of property are under $1 million. And that's important because, as I said before, under the current Proposition 13, you would be able to, as a parent, transfer to your child or have your child inherit your primary residence plus each of these three pieces of real property, and all four pieces of real property would be excluded from reassessment for property tax purposes. Take a moment to think about that. So you can see the power of that $1 million exclusion for other real property. It is not uncommon to be working with families, or I should say to have worked with families in the past, that are able to transfer a decently sized real estate portfolio to their children with little to no property tax consequences. So let's take a look at the difference between then and soon to be now when it comes to that other real property, that investment portfolio I just shared with you. So the Proposition 13 taxes on those three pieces of investment property, I've got them listed here. Again, I'm using that average 1.1% tax rate. They came out to about $8,000 a year. So $8,000 a year was the property taxes that mom and dad were paying on the vacation home and the two rental properties. Now, again, with Prop 19, there is no exclusion for anything other than a primary residence and a farm. And so each of the vacation rental, rental 1, and rental 2 are going to be completely reassessed. And the new property taxes are going to be based on their fair market values. Again, using the same tax percentage, the 1.1%, that comes out to over $40,000 in property taxes a year, which is a difference of over $32,000. $40,000. And it bears noting that the property tax is the gift that keeps on giving. Once your property taxes have gone up to the $40,000 a year, this is going to be your property tax rate for the next, X amount of years that you choose to keep these properties, of course, going up just slightly with annual increases. And so that $32,000 difference is going to continue year after year after year. So after hearing that, I think the first knee-jerk response is usually like, well, clearly I need to transfer my property now. That sounds like what you're saying. But I think it is worth taking a moment, taking a step back, pausing, and thinking about this. Because in order to be able to get your property to the next generation before the property tax laws change, that means giving away or selling your property. And so in doing so, you're likely going to use some estate tax exemption, particularly, if you're gifting property to the kids. It's important to note that although our current estate tax exemption is over $11.5 million per person, and you double that for a couple, that is not a permanent exemption. That is looking to sunset in the year 2026. And it's very likely with President-elect Joe Biden coming into office that this exemption could be lowered, perhaps significantly. And so if you're looking to gift property, which will use some of your estate tax exemption, you need to be mindful of your own tax situation and see if it makes sense to use your exemption in that manner. If you are making gifts, you're going to have to file a gift tax return. These are not particularly troublesome to put together, but generally speaking, you're going to want to hire your CPA or your estate planning attorney to do that for you, and there's going to be some administrative costs involved. In addition, if you're making gifts and you're filing a gift tax return, you're going to need to get that property appraised. For a large real estate portfolio, those costs are something that you should keep in mind. An appraisal for a residence is probably going to be minimal. Appraisals for commercial or multi-unit properties are going to be a lot more expensive. One thing not to be underestimated is your children will receive carryover income tax basis if you gift them the property now versus waiting for them to inherit it when you pass away. And so you need to be mindful that you are not, on the one hand, trying to protect property tax basis, while on the other hand, creating an income tax situation. And what I mean by that is if you inherit property when somebody passes away, that property gets a new income tax basis. It gets a basis based on the fair market value on that person's date of death. And so if you end up selling the property shortly thereafter, there are little to no capital gains that are likely going to be paid. However, if you are gifting this property to your children, they're going to get carryover basis. And your income tax basis is likely based on the purchase price or some nominal amount from way back when, if you've been hanging on to this property for any period of time. Now, again, we don't have a crystal ball at this point, but it's important to note that, again, President-elect Joe Biden may be changing some of the laws. Some of the laws that we have here today may not be in effect later on. And one of the things that he has talked about is limiting the step up in income tax basis at death. And so, if your children are getting carryover basis now and we have eliminated the step up in basis at death, then really you're somewhat in the same position, but we just can't count on that happening at this point. So it's something that you should be aware of. And I'm going to throw in my 2 cents. I think that most people who voted for this did not understand the ramifications to their estate plans and to their families. I wonder at some point, with enough pressure, that our legislature or even our citizens may decide that they want to come together and undo this in the future. And again, once you've gifted or sold property, it's very difficult to undo these types of transactions if you can do so at all. And so these are just some things that I say to you today to have you kind of hit the pause button and think mindfully about what maybe you need to do or what maybe you want to do at this point, given that many of us who owned real property had just assumed it was going to go to our children with the low property tax base that we have come to enjoy. So, we have a lot of tools in our toolbox as estate planners, and unfortunately, not a lot of these are going to work for this situation. When we're looking to transfer property to the next generation, life estates are very popular. You transfer the property to the child, but you're able to keep a life estate for yourself and live in the property for the rest of your lifetime. Well, this tool is likely not going to work with Proposition 19 because if you live past February 15th, or, we mentioned February 11th, but really February 15th, your life estate is not going to work. And that's because the transfer event is going to be after the date of the new law. And so the new law is going to apply. Similarly, what we call grantor retained annuity trusts, or GRATs, aren't going to work if the annuity term ends after February 15th. Now, for those of you who aren't familiar with this tool, you essentially transfer income producing real property into a trust, and the trust basically agrees to pay you back an annuity or an amount of money over a certain term of time. And so again, if that term ends after February 15th, then the new rules are going to apply. And then lastly, the Qualified Personal Residence Trust was a favorite of estate planners to transfer real property to the next generation. It's a little bit like a life estate in that you transfer your home, either your residence or your vacation home, into this trust. And this trust allows you to live in the home for a certain period of time or the rest of your life. And then after that, your children receive it. Again, if the term that you are allowed to stay in the home goes past February 15th, you have a similar issue that the new laws are going to apply and not the old laws. And so Proposition 19 is difficult for estate planners who are scrambling to come up, with solutions for our clients. And a lot of these tools really aren't going to work because of the timeline. Now, it is quite possible that you can go ahead and just make an outright gift to your child of a piece or pieces of real property. Estate planners often caution folks about doing this because, in the case of creditors, including the spouse in a child's divorce, once your child receives this property, it becomes part of their estate. And so that property is in fact vulnerable to a divorcing spouse or other creditors. But an outright gift before February 15th, preferably before February 11th, would presumably work. In addition, it's possible that you can use a gift or a sale or some combination of the two to an irrevocable trust. You essentially transfer the property to this trust. You have to be mindful that each beneficiary of the trust has to qualify for an exclusion under the old Prop 13. That's the parent-child exclusion, but presumably most of us are setting these types of trusts up to qualify. Again, you would have to set up the trust and do all the transfers before that February date. And again, because of the holiday, I am using February 11th and not necessarily February 15th as the sort of dead end date for any kind of action that folks may be taking. Also, one of the things that, may be available to folks is using the legal entity rules. So not many people realize this, but there are different property tax rules when it comes to legal entities. These are partnerships and LLCs. The rules are different than the rules for individuals. There is no type of exclusion like a parent-child exclusion, but because their rules are different, you may be able to game those rules a little bit and possibly kick the can down the road a little bit longer in terms of avoiding reassessment. These really only work for investment real property, and this is very complex stuff. And so one of the things that I will say is please, 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 this is not the time to DIY your own planning. Please do not start drafting deeds and just willy-nilly transferring property to your children and grandchildren. And believe me, I understand the concern with Prop 19 and its effect on your estate plan. But even the old rules when it comes to transfers between parents and children are complex. And there are documents and timelines involved. And really, any gifting or selling or transferring that you're contemplating should be part of a plan. And that plan should be based on a holistic analysis of your situation. So I do have some questions that I want to posit to you. And when I say you, I mean you that are thinking, okay, I think I need to get this looked at. I think I either need to do something or I want to do something. So here's some questions to ask yourself before you reach out to your financial advisor or your CPA or in particular, your estate planning professional. And these questions are designed to really get to whether or not you really should be doing anything in light of Prop 19, because I think many of us will want to do something. But again, you want to make sure that whatever you do is based on a fully vetted analysis of your situation. So the first question that you should ask yourself before you reach out to anyone is, are you potentially going to sell this real estate during your lifetime? Do you envision that, this is something you might hang on to for a while, but at some point you might or probably will need the money for bills or for care or whatnot? If it's likely you're going to sell the real estate during your lifetime, you don't necessarily need to worry about protecting the property tax values for the next generation. Another one that I think is really important is to talk to your kids about the property. If you're protecting the property tax basis for their benefit, make sure that they really see it as a benefit. And what I mean by that is, do they really want to keep the property? Especially if they're going to be co-owners with their siblings. Do they have completely different ideas about the situation? Are they thinking, well, we'd likely just sell any real property if mom and dad passed away? I don't want to be a landlord. We don't want to co-own property together. And so it's important to take the step of having that conversation with your children before you go about trying to protect the property taxes for a property that's very likely going to be sold fairly quickly if you were to pass away. Are you in a good financial position to give away your real estate? Because of course, we'd probably all like to avoid additional taxes, particularly, the idea of our children inheriting property from us and then being burdened by, higher or high taxes. But if you're not in a good financial position to give away your real estate, for instance, as I mentioned a few steps ago, if you're thinking, you're going to need that money at some point or that income, or you're relying on the income from that property now, then it's probably not a good idea to be thinking about gifting that real property before the property tax law change. And if you have a larger estate or a large estate, you really, really need to sit down and look into the estate tax issues. That is, are you going to be subject to tax now? Are you going to be subject to estate tax potentially in the future? And if so, if you're going to use up some of your exemption now, is that the best use of your exemption? And so that, again, is part of the analysis in working with a professional, in particular an estate planning professional, because they're going to be looking at where you sit in terms of potential estate tax exposure. And then the last little thing that I just want to posit here is that there really are no cookie cutter solutions. It is going to be, the analysis of your estate is going to be very much driven by your facts and circumstances. It's going to be driven by what you own, who you're giving it to, your financial position, if you're relying on the income from the property, what your estate tax situation is, and on and on. Because there are no cookie cutter situations, because you need to do a holistic analysis, in order to make sure you're not trading one tax issue for another tax issue. You're going to have to go in and spend some real legal dollars to get your situation assessed, more than likely. And so that's also something to be prepared for, is whether or not you're willing to, spend a little bit of money in order to come up with a solution to the situation. And if you're not, again, then maybe it's not the time that you need to be doing something or that you want to be doing something. All right, so thank you so much for coming to this presentation today. I really do hope that you were able to get some additional insight into Prop 19 and how it works and how it's going to potentially affect your estate. I do think it's very important that you be aware of some of the updates that are likely coming down the pipeline. The Board of Equalization, the legislature, they're going to be weighing in on Prop 19 in the foreseeable future. Once we get the confirmation of the vote in mid-December, we're going to start to see more information coming from these sources about how the tax is going to work, the specific structure of things, the calculations of the tax, and then again, administratively, forms and deadlines and things like that. And so I would encourage you to follow me as we get new updates. I am going to be updating my blog. I'm going to be posting on LinkedIn and Facebook. I have my contact information here. You can always find all of this information on my webpage, which is nw-trust.com. And you can also visit the Board of Equalization for updates. They've got a specific Prop 19 page at this point, and I think they're going to have that up for the foreseeable future. And so as information is being disseminated by them, they're going to update that page as well. I thank you so much again for coming today. And again, keep an eye out for updates. This is going to be an ever changing legal situation. And if you do think that you're in the position where you need or want to be getting real property to the next generation before the implementation of Prop 19, then again, I encourage you to talk to your financial advisor, your CPA, or your estate planner about how to begin that discussion. Thank you so much.